Hey everyone, welcome to Legalbytes. I'm Alyte, and on this channel we explain the law one bite at a time. Today we're continuing our series unpacking the lawsuits filed by Epic Games against Apple and Google. In the last video, we went through 2 of the 4 main legal theories put on by Epic and its complaint against Apple. In this video, we're talking about the last 2 legal theories. Coming on up on Legalbytes. So if you've seen the first 2 videos in the series, I think this video should be a little bit easier to follow along with since we have less foundation to go over than we did in the last couple of videos. But as a reminder, in the first video, we went over the basic allegations that are general to both lawsuits, and we went over some of the background of antitrust law. In the last video, as I mentioned just a second ago, we did a deeper dive into Epic's complaint against Apple. If you're just coming into the series, you might want to check out those 2 videos so you can understand what it is that we're really talking about here. Otherwise, in this video, I'll give a super brief recap on the basic legal theories in the complaint, then I'll go into depth for the last 2 legal theories, and then I'll give our conclusion. Okay, let's get into it. So if you remember from the last video, I pointed out 4 main legal theories put forward by Epic in its complaint against Apple. Those are unlawful monopoly maintenance, denial of an essential facility, unreasonable restraint of trade, and unlawful tying of monopoly power in one product market to another product market. As a quick refresher, unlawful monopoly maintenance is where a business that has a monopoly power in a relevant market essentially holds on to that monopoly power through anti-competitive means. Remember that it doesn't make all monopolies illegal, and in fact, I pointed out last time that the United States Supreme Court has even said before that monopolies can be good things because they often are a result of a business trailblazing into a new market or innovating to make products better. So there's nothing inherently wrong with a business being a monopoly. It's really only when a monopolist uses tactics that are meant to protect itself from competition that any antitrust law might be broken. The next legal theory we went over was denial of an essential facility. If you don't remember, denial of an essential facility has to do with a monopolist having control over a certain facility or an asset, which is crucial to competition in that market, and where the monopolist denies competitors access to the facility. In the last video, I pointed out the example of a mountain used by ski resorts as an example of an essential facility. You can't reasonably recreate the mountain or its geography, conditions, etc. And so a ski resort next to that mountain that's denied access to it will surely go out of business because they can't offer any ski slopes to its consumers, and there's no getting around that barrier. Courts have therefore said that the monopolist that owns that mountain has to share it. Finally, I took quite a bit of time in the last video to go over whether Apple is a monopolist in this lawsuit. This is because each of these 4 legal theories really kind of turns on that question. For the most part, Epic has to prove that Apple is a monopolist in the particular claimed market in order to win on any of these legal theories. If Apple can show that it is not in fact a monopolist in the market, then Apple should win on each claim, and that would be the end of it. Remember that in order for Apple to have monopoly power, or in other words, for Apple to be a monopolist, Apple has to have a dominant share of a relevant market that is protected by entry barriers. In order to figure that out, we of course needed to define the relevant market. Again, if you haven't seen that analysis, I really encourage you to do so because rather than rehash all of those details again, I'm going to skip to the conclusion on that issue and say that I personally think that Epic is correct in defining the 2 relevant markets as the iOS app distribution market and the iOS in-app payment processing market. Because of that, I think that Apple in this case is properly defined as a monopolist. Now, we got some responses from some people saying, well, duh, of course Apple's a monopolist. It's a huge company, one of the tech giants, blah, blah, blah. While it might seem silly to go through that analysis since Apple is worth around $2 trillion, it's not a given that Apple is always going to be a monopolist in every market. For example, there would be a completely different analysis for Apple's role in the wireless earbuds market, and I would conclude that in that market, Apple is probably actually not a monopolist. That's because, first, the relevant market in a case like that wouldn't likely be limited to just AirPods because you can use AirPods for an Android, and likewise, you can use wireless earbuds from other brands with an iOS device. So you don't have the same sort of stickiness in crossing over between Apple and other brands for that type of product as you do for the iOS App Store, etc., which is a factor that would show that AirPods are part of a broader wireless earbud market. And then because Apple has around a 35% share of all wireless earbuds sold, that really isn't enough of a share of the market to be considered a dominant share. Usually it needs to be over 50%. So that's just an example to illustrate how Apple, although very large, is not always a monopolist as the term is defined in antitrust law. Okay, so that's it for the recap. If you want more detail, go check out the previous 2 videos. Otherwise, on to Epic's last 2 legal theories against Apple. So now we have the last 2 theories, unreasonable restraint of trade and tying. Unreasonable restraint of trade happens where a monopolist in a particular market somehow restrains trade in that market, usually through some form of a contract, in such a way that competitors can't reasonably get around it in order to compete with the monopolist. Epic actually makes 2 claims for unreasonable restraint of trade, first connected to the iOS app distribution market, and second to the iOS in-app payment processing market. First, Epic claims that Apple forces developers to agree to the Apple Developer Agreement and to comply with Apple's App Store review guidelines, and that part of this agreement is the requirement that iOS developers distribute their apps through the App Store. Epic further claims that this requirement unlawfully forecloses the iOS app distribution market to competitors to maintain Apple's monopoly. Second, Epic claims that through the same developer agreement, Apple forces developers to agree to use Apple's in-app purchase for the sale of in-app content to the exclusion of any alternative solution or third-party payment processor. Epic further claims that Apple unlawfully prohibits developers from directly or indirectly targeting iOS users to use a purchasing method other than in-app purchase. Although Epic doesn't put a specific label on the claims, what Epic is getting at is essentially a claim that Apple is engaging in exclusive dealing. The courts define exclusive dealing as a situation where there's an agreement between a seller and a buyer which prevents the buyer from purchasing a given good from any other seller and which forecloses competition in that market. For purposes of this claim, when I say seller and buyer, think of Apple as a seller and the app developers as the buyers. Now, when you look at this definition, it's easy to say, but every contract does that to some extent. That's the meaning of a contract, is to set up an arrangement between a buyer and a seller for something, and sometimes that's for exclusivity. There are a whole host of benefits to exclusive dealing arrangements, so how could that be unlawful? To respond to that, yes, there are economic benefits to exclusive dealing arrangements, and courts have long recognized that they can actually enhance interbrand competition. Exclusive dealing arrangements can assure supply, price, investment, etc., which can ultimately benefit consumers. So courts don't necessarily want to outlaw all exclusive dealing arrangements, only certain types. Specifically, courts want to prevent a monopolist from unreasonably depriving other suppliers of a market for their goods by claiming up all of the potential buyers as their own. That means that the legality of an exclusive dealing arrangement depends on whether it will foreclose competition in enough of the relevant market so as to adversely affect competition. An exclusive dealing arrangement is only unlawful if the probable effect of the arrangement is to substantially lessen competition rather than just disadvantage its rivals. Although in most federal circuits there's no set formula for the legality of an exclusive dealing arrangement, generally 4 things are needed in order for a plaintiff to win on this theory. 1. Significant market power of the defendant. 2. Substantial foreclosure of the market as a result of the agreement. 3. Contracts lasting long enough to prevent meaningful competition by rivals. And 4. A showing that the anti-competitive effects outweigh the pro-competitive effects. However, in the Ninth Circuit, which is where Epic has filed this lawsuit, the standard is actually a little bit higher. The plaintiff has to show that the exclusive dealing arrangement didn't just create a probable effect of lessening competition. The plaintiff has to show that the arrangement actually foreclosed competition in a substantial share of the market. And what's more, the plaintiff also has to show that there's really no way to get around the arrangement to provide a competing product to the buyer, say by simply offering a cheaper or a better product. So in the Apple case, Epic alleges that Apple requires every app developer selling their app on the iOS App Store to agree to the terms of the app developer agreement. Epic also alleges that the terms of the developer agreement state that the developers agree not to distribute any other apps through their app or to facilitate any in-app payments other than through the iOS App Store. If you agree with the conclusion that it's proper to draw the boundaries of the relevant market around the 2 markets Epic alleges, meaning the iOS app distribution market and the iOS in-app payment processing market, then Apple is a monopolist with more than significant market power over both markets. Next, this agreement does foreclose 100% of each relevant market to any would-be competitor iOS app distributors or in-app payment processors. 100% is definitely a substantial portion of the market. Third, although there doesn't seem to be any time that the agreement is supposed to last, it does seem that it prevents meaningful competition by rivals in both of the relevant markets because it explicitly requires a 100% exclusivity agreement. Before we talk about the balancing act and number 4, let's look at the other factors that are a little more particular to the Ninth Circuit. It has to be that there's no way for a would-be competitor to get around the exclusive dealing arrangement. So far, none of the gaming apps that were rejected by Apple have been able to reach iOS users. So it seems like there really is no way around the arrangement. And as for the requirement that it actually foreclose competition, in the iOS app distribution market, I've referred multiple times to the 3 gaming app distributors that tried to get onto the iOS App Store and were rejected. So there is real evidence of competitors actually being foreclosed there. On the other hand, in the iOS in-app payment processing market, Epic talks quite a bit about potential competitors like PayPal, Braintree, Stripe, and Square. However, there's no allegation that any one of them have actually tried and failed to compete with Apple in that market. Because of that, it's not clear that their competition has actually been foreclosed, which is probably the main reason why Epic released its app update in Fortnite last month. That's right, I don't think that Apple was just trying to be dramatic by trying to sell V-Bucks directly to iOS and Android users. I think they likely did it so they can check this box. Because Epic now has pretty clear evidence that it has actively tried to compete in the iOS in-app payment processing market and been walloped by Apple as a result, Epic can in fact show that the particular market has also been actually foreclosed by Apple's enforcement of the terms of the app developer agreement. Now, just like with Epic's monopolization claim, Apple will likely have an opportunity to show that the anti-competitive effects are outweighed by pro-competitive justifications. The same potential justifications I mentioned in the last video for the first 2 legal theories are likely to apply to this claim as well. If you remember, I mostly talked about privacy and security justifications, but Apple can also point to things like efficiency, storage limitations in mobile devices, and other arguments. One common pro-competitive justification that's used in exclusive dealing arrangement cases is preventing freeloading on their investments. For example, take a case where a dominant manufacturer sells its product to consumers through dealers. The manufacturer might invest in getting sales leads and then send those leads to the dealers. And then the manufacturer might make an agreement with the dealer by saying that if and when the manufacturer sends those sales leads to the dealer has to sell the consumer the manufacturer's product and not a competing product. A potential pro-competitive justification for that arrangement is that the manufacturer has invested money in developing those sales leads, and the exclusive dealing arrangement prevents the dealer from freeloading by getting some better sales deal from a competitor who hasn't had to make that same investment. So in the context of an exclusive dealing arrangement, Apple could argue that there's some reason along those lines. For example, Apple could argue that they've invested a ton of money in the iOS App Store and that a business should be rewarded for its investment into that kind of technology, etc. That said, I don't know how convincing of an argument that would be. Microsoft invested a ton of money into its OS and into its web browsing technology, and they ended up having to share all of that with competitors. We'll see what Apple has to say though, because maybe they have some really compelling arguments. Moving on to the 4th legal theory. Tying. This happens where a business has a lot of market power in a particular market and uses that market power to force the sale of another product onto the buyer. They do this by conditioning the sale of the product they have market power in, also known as the tying product, on the buyer's purchase of a second product called the tied product. To illustrate, let's say a business has a monopoly on all the oil in the world and consumers need oil in order to make their cars run. If that business then says, in order to buy our oil, which is the only oil you can buy because we're a monopoly after all, you have to buy our tires for our car. That's an example of tying one product market to another. Now, it's not unlawful for a business to bundle multiple goods or services together, obviously. Businesses do that all the time, and it can reduce pricing, increase quality for consumers, and more. So it has to be something more than just bundling different products in order to violate the Sherman Act. So in order to win on a tying claim, a plaintiff has to prove the following. 1, that the defendant tied together the sale of 2 distinct products or services. 2, that the defendant has enough economic power in the first market, the tying market, to coerce the buyers into purchasing the other product, or the tied product. And 3, that the tying arrangement affects a substantial volume of commerce in the tied product market. In this case, Epic claims that through Apple's App Store review guidelines and the app developer agreement, Apple has unlawfully tied its in-app payment processor, in-app purchase, to the use of its App Store. In other words, Epic is saying Apple is using its monopoly over the iOS App Store and extending that monopoly into the market for payment processing of in-app content by requiring app developers to only use Apple's in-app purchase feature to process those payments. So first, Epic has to show that the App Store and in-app purchase are 2 distinct services. Some factors Epic might point to are the fact that there are apps that get distributed on the iOS App Store that don't use in-app purchasing, as well as the fact that consumers make electronic purchases that are similar to in-app purchases all the time in contexts that are separate from the App Store. Another factor Epic could point to in order to show that they're two different services is the fact that the competitors Epic highlights for the iOS app distribution market are entirely different businesses than the competitors Epic points to for the iOS in-app payment processing market. So it seems that the court might find that these two markets are distinct. Continuing on with that, Epic alleges that the developer agreement, which is what Apple has all iOS app developers agree to in order to sell their apps on the iOS App Store, requires that app developers agree to use Apple's in-app purchasing for all payment processing for sales of in-app content. So it looks like the first element is met. Then Epic also needs to show that Apple has enough economic power over the App Store that it can and does exploit its control over the App Store to force app developers to go through in-app purchase for the sale of all in-app content on iOS mobile devices. As for market power, we of course already went through that, and you may or may not disagree, but I think Apple is most likely a monopolist in the iOS app distribution market. So I think that the second element is met. Finally, if we conclude, as we did in the last video, that the iOS in-app payment processing market is a proper definition of the relevant market for in-app purchases, then iOS in-app payments make up 100% of that market. That in turn means that the developer agreement affects 100% of the market, which is a substantial volume of the commerce in the tied product market. So then, thinking about any pro-competitive justifications Apple may have, Apple may say that they need to review all of these apps on a regular basis in order to ensure that they're safe and secure for iOS users. And Apple may further argue that it would take an inordinate amount of time and expense to review the safety and privacy features in payment processing setups when the payment processors are not in-house at Apple. In other words, Apple might say that keeping the sale of in-app content to just in-app purchase means less time and effort that Apple has to spend worrying about some other payment processor's potential lower standards. And that in turn could mean savings in time and cost for consumers. But again, that burden is going to be on Apple to show pro-competitive justifications for conditioning admission of an app to the App Store on the agreement to use only Apple's in-app purchase to sell in-app content. At this point in time, I'm personally inclined to think that the pro-competitive justifications are likely to be a little weak for the tying claim because, as I mentioned before, we go through online purchases all the time outside mobile apps, even through browsers like Safari on iOS mobile devices, and there doesn't seem to be any crazy issues. So unless Apple puts up a really convincing argument, I'm leaning towards Epic on this one. So that's the meat and potatoes of the Apple complaint. To wrap things up in this video, we went over the last two main legal theories in Epic's complaint against Apple. First was unreasonable restraint of trade, which is basically a claim of unlawful exclusive dealing arrangements. Because I think Apple is a monopolist in both relevant markets identified by Epic, and because Apple's developer agreement appears to totally foreclose any competition through these exclusivity terms, I think Epic can win on this claim. Second, we went through Epic's tying claim. Because the developer agreement pretty explicitly states that it's a requirement that app developers use in-app purchase, and because Epic went through with its Fortnite V-Bucks direct purchase stunt and was actually foreclosed from accessing the App Store as a result, I think Epic has a decent chance of winning on this one too. And that leads me to a final note on these four legal theories. In order to win on any of these legal theories, Epic needs to prove each and every element of the claim. But in order to win the case, Epic doesn't necessarily need to win on all four of these legal theories, although Epic surely wants to win on all of them, and especially as they apply to two different relevant markets in question. But if they lose, for example, on the exclusive dealing arrangement claim, and then win on the essential facilities claim, Epic could still be entitled to some form of injunctive relief, like I talked about in the last video. So there is quite a bit of pressure on Apple, who, in order to win, needs to poke enough holes in each and every one of these claims to prevent Epic from winning on any claim. Otherwise, if Epic wins on just one claim, Apple might have to open its iOS for other competing app distributors, or change the terms of the developer agreement to allow apps to distribute other apps, or allow other payment processors to facilitate the sale of in-app content. It all comes down to what the court thinks will be best for competition and ultimately for consumers. Okay, so that's it for this one. If you've stuck with me through all three of these videos we've made on the series so far, I give huge props to you. As I've mentioned before, this is complicated stuff. And if you've made it to this point, let us know what you think in the comments below. Are you inclined to think Epic might have a decent case here, or do you think Apple is going to wallop Epic in the end? Comment below. Otherwise, as always, I hope you found this informative and useful, and if you did, we'd love it forever if you would hit the like button. And if you're new to our channel and you want to see more, hit the subscribe button and the notification bell so you can find out when the next video is uploaded. Thanks.